This is docket 9300 DR 105, the petition of Midwest Renewable Energy Association, the petition to determine applicability of a third-party financed distributed energy resource systems. This is Mike Newmark, Administrative Law Judge for the PSC. And we're here for a pre-hearing conference, our second in this proceeding. We have many people connected. I can't say that all parties are right now with us, but what we'll do is take appearances on the record, and then we can get into the topic of today, which is really simply setting the schedule, I believe, unless people have any other ideas. And I think the easiest thing to do with a case this big is just to run down our service list in alpha order, and we'll just get appearances from each party in turn. So first of all, we have Citizens Utility Board. Who do we have representing CUB? I know, I think Corey Singletary is connected. Can you hear me? He was. Yes. Okay, well, let's skip from him for now. Okay, is City of Milwaukee present? Let's see him there. About Clean Wisconsin.
Good afternoon, Your Honor. Brett Cordy on behalf of Clean Wisconsin.
Thank you. Customers First Coalition.
Eric Callisto of Michael Best and Friedrich for Customers First.
Fair Rates for Wisconsin's Dairyland.
Good afternoon, Justin Chasko and James Waywood from Frederickson and Byron.
Great Lakes Utilities. I can unmute you myself from.
No, I just did it. Sorry. Anyway, Richard Hyman from Boardman Clark.
All right. IUOE Local 420. Don't see them on the list here. MG&E.
Good afternoon, Your Honor. Brian Kleinmeyer of Stafford Rosenbaum for MG&E.
Hello. All right. MREA.
Good afternoon, David Bennett for MREA.
Okay, so you're kind of cutting in and out a little bit on your mic, but just be mindful of that when we start the substance here. NSPW, Northern States Power, anyone? I think they're connected. Public Service Commission.
Your Honor, Stephanie Bedford, Assistant General Counsel, appearing on behalf of the Public Service Commission, and with me is Assistant General Counsel Evan Weitz.
Thank you. Vote Solar.
Good afternoon, Your Honor. Nick Kilbajaker from Keys and Fox on behalf of Vote Solar. And Your Honor, I had a question for you about service list updates that I can ask at the end of roll call if you'd like.
Let's wait for that. Thanks. Walnut Way Conservation Corp. Don't see them connected. Wisconsin Electric Cooperative Association.
Me, Your Honor, Justin Chasko and James Waywood again. Thank you.
All right. Wisconsin Electric Power Company.
Hi, Judge Newmark. Kate Phillips on behalf of Wisconsin Electric Power Company.
All right. And okay, I may have this is how the list looks. Okay, so we do have Quarles and Brady also representing Webco. Is that still the case?
Yep, that's correct, Your Honor.
How about Wisconsin Power and Light?
Yes, Your Honor, Zach Ramirez appearing for WPL.
Okay, and your audio is very disturbed for some reason.
I apologize, Your Honor.
Oh, maybe it's just your finger was in your ear.
Okay.
That was probably the reason. All right, no, we'll see how that goes. All right, Wisconsin Public Service Corporation.
Again, Kate Phillips on behalf of Wisconsin Public Service Corporation, and I believe, I'm just looking, we have Brad Jackson and Patrick Proctor Brown also on from Quarles and Brady for both Wisconsin Electric and WPS.
Yep.
Thank
Okay.
you.
Okay, and Wisconsin Utilities Association.
Good afternoon, Your Honor. Attorney Patrick Proctor Brown and Attorney Brad Jackson is also on the line.
Right. I just want to confirm you're still representing Webco and Pub Service.
That's right, Your Honor. Yes.
And Whippy Energy.
I don't know that Tom is on the call, but Richard Hyman representing WPPI Energy, and would also, again, of Boardman Clark, and want to also note that I'm representing Municipal Electric Utilities of Wisconsin, which we skipped over on the roll call.
Okay, yeah, sorry about that.
No worries.
And let's just swing back over to Cub. Who's representing Cub today?
Good afternoon, Your Honor. Corey Singletary on behalf of Cub today.
All right, great. Okay, so that's appearances on the record. Great. So we had a question about, we can go off the record, a question about updating the list.
Yes, Your Honor. I think in the past, you've asked if there were any service list corrections, and I have one just for our business address, but if you'd prefer that I submit that as a request to the service list or to yourself by email, I can do that.
Okay, actually, if you could file that under request to intervene and put that on IRF so that everyone has that in the public record of that. So just file a notice of appearance under the request to intervene document type, and just with any corrections on the list you need.
Okay, will do. Thank you, Your Honor.
Yeah. All right, I don't think we need the screen share anymore. Nothing really to show people today. So we might as well get on the record here. We're going to be discussing the schedule. I think the notice period conference established, and the order to reopen the record established that the issues and parties are the same. So facilitating matters are the same. So we're just going to check out the new schedule and just be aware that the issues are fairly limited by the commission. They had a pretty particular list of items they wanted to review and seek additional evidence. So with that in mind, just seeking for proposals for the schedule. Oh, and also we do have the data that was requested by the commission of MREA, and MREA did respond to that. So we do have the information that MREA was sharing with us regarding that that request. So at this point, setting the schedule, we want to get the information the commission requested into the record, and we're just providing a process to do that. And so, I mean, I'm open to suggestions. However, simple or complicated, we want to make the process, but I think it would be fair to have the petitioner provide any suggestions it has first for the process, and then we can move on to the other parties. And I just wanted to confirm, is WUA speaking on behalf of the of utilities still, like they had been in the past part of the proceeding?
Yes, Your Honor. We did confer about with the other utilities and with other interested groups that are kind of aligned with WUA on a proposal, and I think we can essentially represent that group subject to check from everybody else on the line.
Okay, well, they're here, so
Right.
just yeah, everyone. I'll give everyone a chance to comment, but if you wanted to take point on the I guess respondents' end of the case, that would be useful. So thanks. So let's hear from the petitioner. Any suggestions for the process going forward?
Yeah, thank you. Can you hear me okay?
I can. Okay.
So the petitioner's view of the order to reopen and the limited issues was that the commission was seeking information from the petitioner specifically, and we complied with that as best that we could already. And so as far as we're concerned, the process should be mostly complete. We'd note that in other similar reopenings where the commission had specific questions, that from our review of those procedural orders after the reopening, it was limited to either that information or maybe some brief comments from parties on it to the extent anyone has anything to say. The questions were mostly aimed at what MREA plans and what it knows. I don't know that there's anything for other parties to really add that's within the four corners of the questions. To the extent that the commission intends to reopen for additional testimony and briefing or anything else, we'd ask that it be limited both in scope and in time. Ideally, so we could wrap all of this up before everyone's busy with rate cases late summer and in the fall.
Okay, and any suggested process from you?
Well, our suggestion is that the commission, if the commission wants information from other parties, to open up a comment period for the other parties. Assuming that that's going to trigger an interlocutory appeal to the commission about the process. And to avoid that, we're also open to testimony from parties, responsive testimony, if that's more appropriate.
Okay, so nothing specific. All right. Okay, so let's hear from the other side. I guess WUA want to proceed.
Thank you, Your Honor. So I just note at the outset, we're the only party that timely proposed a process for this proceeding in accordance with your notice. And that process, we attempted to make sure that the commission has a full record. So responsive testimony to the testimony that MREA has already been submitted to the commission. I think that even the concept of submitting testimony from MREA presupposes a hearing. So that will be kind of point one. We think there should be a hearing. Otherwise, there's no basis to accept testimony from MREA as opposed to comments or some other kind of evidentiary submission. And so we believe that 45 days is appropriate, and that's the proposal that we made to submit responsive testimony. And then, as Attorney Bender said, it's a very complicated summer, really September, for the commission and for a lot of the parties on this call. So our proposal was then to push out the hearing into the early October period, so October 9 to 13, and then initial and reply briefs after that, so that they aren't coinciding with all the rate cases. So we didn't get any comments back from anyone in this group on the day of proposals being submitted in accordance with your order. But the next day we received from Mr. Bender a proposal, which he just made now, which is to close the record after the petitioner puts in their testimony. And that's simply unacceptable to us. We think we have a statutory right to present countervailing evidence. And because the evidence that he submitted as MREA was testimony, it's at a hearing. So we're all here because you issued a pre-hearing notice, or a notice of a pre-hearing conference, which we think presupposes a hearing as well. That's what the commission did in the opening stage of this proceeding and should do now. Now, we're totally open to compromise to accelerate the schedule. And my understanding is that staff wants to proceed with alacrity, but I think it's really kind of non-negotiable for us to have 30 days so that we can issue discovery to MREA, which we plan to do either today, tomorrow, or Wednesday. 21 days is what the facility matters for the scheduling conference order permits to respond to discovery. And then we need at least a little bit of time to incorporate that discovery or responses or select a witness to submit that testimony. So we think anything that we do here should have a hearing, and the earliest date we think that responsive testimony should be due is July 26th, 30 days from today. But everything else, I understand MREA doesn't want to submit additional testimony except live at the hearing, which we're fine with. And we're fine with pushing the hearing into early August so that we're before the complications of the various rate cases that are coming before the commission.
Okay. All right. Well, now you get a chance for your aligned parties to contradict you. So any other comments from other parties or staff? I mean, yeah, okay, let's have parties first. It doesn't sound like there's any parties. I shouldn't have rope staff into there too. But so go ahead, Attorney Bedford.
Yeah, I just want to point out, first of all, staff would have responded promptly, but I was not included on the email list with WUA's proposal and didn't get it until after the deadline had elapsed. But we are generally, our interests are generally aligned with MREA in wanting this sort of supplemental proceeding to the primary docket to move forward with alacrity. And our concern with having this butt up against rate cases for us is something that we also share with MREA. The proposal that WUA submitted, having the hearing in the first week of August, is something that I think that staff could potentially agree to. What we anticipate in terms of the issues in this, that it's going to be fairly simple and straightforward. And I think we might have one data request for MREA that's going to be very simple. So.
Okay. Anybody else? No comments? No? Yeah, that's actually shockingly reasonable schedule. So I did want to, so I think the 26th will work for a round of testimony, and then we'll go to hearing on August 1st, 10 a.m. Does that work for everybody? And I just wanted to mention, I know that the discovery deadlines was cited by WUA as sort of a one basis for asking for more time than MREA is considering. But parties need to understand and should already be aware that you're already parties to the case, and the case, we already have a facilitating matters order in play that sets these deadlines. I don't see any reason why discovery couldn't have begun at the outset of the order to reopen. I mean, it could have happened even that early. Sure, it certainly could have happened after MREA filed its response to the commission's request for information. So there's been plenty of time already to sought discovery. Regardless of that, however, it fits my schedule, it fits the commission's schedule to hear the issues on August 1st, so we can set it at August 1st. So I'm thinking 2 weeks and 1 week for briefing. Does that work for everybody? So 15th and 22nd.
I believe that'll be fine. I do have a question on that.
Well, let me just poll everyone for that. So it looks like WUA is on board with that. How about MREA?
We do one round of briefing, given the narrow issues here, and also set up a shorter than typical page limit to make sure that the scope of what we're briefing is correctly focused on this reopen issue, and we're not rehashing again all the arguments we've made.
Okay, response.
Well, I say that feeds into the question I wanted to ask, right? So I don't know what the process will be for getting this docket back to the commission if they haven't actually made any determination on the issues in the first phase. And I would think that they need to be provided all the issues for their open meeting in some way, particularly with a new commissioner. If it's simply a matter of having the briefs and as part of the record that's provided to the commissioners prior to their open meeting, I think we would be fine with limiting those briefs. We don't agree to not having a reply.
Okay. Yeah, the briefs have to be limited to the issues that are presented as part of this part of the process. So the existing briefs are in the record and will be available to the commission as well as all the other documentation in the record will be available to the commission for its final decision as the basis for its final decision. So yeah, limiting the briefs. I mean, we could limit the briefs to the issues. I think that's just implied, but I'm glad we got to make that clear to everyone. discovery as well is limited to the commission stated issues in the order to reopen. So, and testimony is also limited to the same. So just make sure everyone understands that, but also that the record that was produced last year will also be part of the case before the commission when it makes its final decision. So, you know, I don't really feel the need to make any limitations at this point. Like I said, this does fit my schedule. It fits the commission schedule. So I'd rather just leave our kind of standard practice in play, and so as not to kind of, you know, create new variables in our process, especially in a case that this contentious. So I think we'll do 15th and 22nd, do at 1:30. Just keep that standard. And I actually can't recall whether all the parties filed a brief or was it the WUA filing a single brief. So
I believe there were multiple briefs.
There were multiple briefs.
I wouldn't limit the other parties to not filing a brief. It's certainly, I think, their right to comment to the commission.
Yeah, so okay. So if that's the case, and we probably did, no, this is, it's all coming back. So then we got an extension, or we got increased page limits for MREA last round. I can't recall.
I don't recall that either. I don't anticipate the need for increased pages if we're limited to the issues, but I think we would want to be able to reply to MREA's open brief.
So I guess, yeah, so I guess just limited to the issues. I mean, if it's 30 pages for each party, that's probably excessive for this case at this point. But I guess I don't want to limit it now. So just be aware that that's, you know, this is a limited case. I doubt you really need to get that far on your briefs to make a clear case to the commission. So no, I'm not going to limit anything at this point, but okay. So anything else?
Your Honor, I was just going to add that WA will endeavor to submit individual briefs on behalf of obviously the utilities and the aligned groups as well. Can't guarantee it at this time. We haven't hashed things out yet, but that would be our expectation. And obviously we're not going to file a 30-page brief on the limited subject matter. So I don't think that's a concern.
Okay. Yeah. I appreciate you making that clear. Thanks. All right. Anyone else? Yeah, go ahead.
One question just occurred to me. Is the deadline 21 days at this point for discovery, or are we into I recall that the timeline's shortened as we get further into the case, and I'm not sure if we restart or if we're within the shorter timeframes. So
right. Well, okay. Sorry. Yeah, it would be after rebuttal, the timelines start shrinking, if I recall correctly. So right now we're in the direct phase. So I think that's a pretty big number of days, which we can shorten to make this process move along according to the schedule. So I'm not sure if WUA has and the other parties have an idea of when they would be filing any discovery.
Our goal is to file it shortly after, we'll serve it shortly after this hearing. So today, tomorrow, Wednesday, to make the schedule move along. We've certainly drafted it. We just need to finalize it.
Okay. Yeah, I didn't let's go off the record for a second. Let me get the order in front of me. Because yeah, that would be quite a bit of time. And then okay, yeah, let me just get that up. Had this problem in the morning. So before rebuttal is due, there's 21 days to serve a response. After rebuttal, it's 7 days. So if we were to limit that time, I think that would be necessary. So we could do it 11 and 5. Or 11 and 4, maybe.
I don't know that we have a position on it, to be honest. We'd like to get what we need, and if MREA thinks they can hold themselves to a tighter deadline, that would be fine with us. I don't think my understanding is MRE doesn't intend to do any discovery to the other parties, since they believe it's a limited case and doesn't require a hearing. So,
well, that's true, except you will be filing testimony, so that may trigger the need for discovery question. But so I don't know. So Attorney Bender, any comment on that?
I mean, we're willing to tighten the deadlines, but we'd ask that be then linked to shortening the 30 days for rebuttal was tied to 21 days for discovery. So for shortening discovery, we'd ask that rebuttal deadline be moved up by a similar period to provide then more time between that round and then the hearing.
we can shorten it to some extent, but I would say that's not the only reason to have
Yeah.
30 days. As you can see, there are a number of parties on this call that I think I'm at least tacitly speaking for and require the coordination with prior to filing that testimony. So the discovery deadline is one part of the need for 30 days, but we also need to coordinate and make sure that everyone that has an interest in the testimony that we file has had an opportunity to take a look and finalize that testimony. So if we move to 11 days, maybe we could do 21 days or 25 days for testimony, but I don't think we should be limited to less than that, 3 weeks.
Well, why don't we can do discovery on the direct due on July 14th. And then '26th. Well, that doesn't really leave any. So then we could have the rebuttal due the 21st. No, that doesn't need to be the 21st, and then the hearing on the 2nd. That would provide enough time to get responses back from everyone.
Your Honor, this is Eric Callisto,
Yeah.
Customers First. If you're suggesting moving the hearing to August 2nd, I believe we already have a hearing that date.
No, did I say 2nd? Sorry, I meant the 1st. Yeah, thanks for chiming in there.
Thank you.
I think that would be fine to us, but subject to check with everybody else on the call.
Mm-hmm. Okay, I'm gonna go off the record. Okay, there we go.
That you had set off the record before you just started talking now. So
Yeah, I know. We're even
Keep-
more.
Okay, just
I let
keeping my
cat out.
hands up so you see them.
Yeah. So how does that sound?
It's not our intent to make this long. We just, nobody has expressed any reason for us to rush. And we generally believe a little bit of time creates a better record for the commission. So
yeah,
we're happy to do that schedule.
Okay.
Continue to shorten up the schedule as we've gone along, and that's fine.
Okay, so let's do that. So let me rejigger this.
If we're setting a deadline, a date certain for a discovery response.
Yes, I think that would.
That assumes, I guess, that the discovery is served today, tomorrow, and not the day before the 14th.
Right. Today or tomorrow.
That's fine.
Yeah. So, oh, look, and so, yeah, just give me any other further comments you have, Attorney Bender, and then we'll go on the record for that.
That's my only comment. I mean, I'd also just note that the parties have had the testimony, the 4 pages of testimony already for 6 weeks. So there's been time already. I don't know that we need that much more, but
I understand. I just say we understand that, and that's a point, that's a valid point. But if you don't know how you're going to get that evidence into the record, because we haven't had a pre-hearing conference, there's no point in issuing it, right? So we could have expedited that process and ended up with no hearing and just spun our wheels on discovery. So I think we're moving as expeditiously as we can to get this hearing teed up for the commission.
Okay, so let's get on the record. I'll just state the schedule that we have this at this point. So we're going to expect the data request, discovery questions from respondents. And I don't think I called you respondents before. I don't really know what to call petitioner respond. Well, for the utilities and people aligned with the utility. That deadline for discovery requests will be 627. Then the deadline to respond to that discovery is 7/14. The deadline for rebuttal is 7/21. And the hearing is August 2nd. First brief will be August 15th and reply August 22nd. So all the deadlines for filing will be 1:30 p.m. The hearing we could do at 10 a.m.
August 1st for the hearing, right?
Did I said it again? August 1st, yes.
Okay.
August 1st.
And sorry to cut you off, Eric. I think you were commenting too.
Yes. Okay. So we're all aligned on that. Anything else?
Are you expecting the hearing to be in person or remote still?
Remote. Okay. All right. Well, I think we did what we came here to do. So thanks very much. We're adjourned.